Hey folks, I'm attorney Roger P. Foley, and today I'm going to speak to you about Florida Statute 784.011 and .021. What is that? That is the crime of assault and aggravated assault. Let me give you an example. I'm going to kick your ass. I'm 270 pounds. You're a yoga instructor. I have the present ability to beat you badly. You have a reasonable fear because I'm coming towards you, telling you I'm going to kick your ass. Right? That is the crime of assault. It's not the touching, it's not the hitting, it's the me telling you either verbally or by action. For instance, if I went like this and I was coming towards you and I had the present ability, or I put my hand up, that is assault, punishable in Florida by a maximum of 60 days in jail. So you tell someone you're going to whoop their ass and you have the present ability to do so and they have a fear that you're going to do it, you're facing 60 days in the county jail. What if, change the facts a little bit, I take Lady Justice here that probably weighs about 15 pounds and I tell you I'm going to crack your skull open, all right? And I come towards you with this and I want to smash you in the face. That is aggravated assault. Now if I smash this down on you, I'd probably break your head and break your neck, and that would be aggravated battery. However, I just show you I'm going to smash you, right? That is aggravated assault. I could do it with anything. I could have a knife in my hand. I could have a hammer in my hand. I could have, I don't know, something silly. I could have a stapler in my hand that could do harm. I'm going to staple your, right? I'm going to staple your ass. That is aggravated assault. That is punishable by up to 5 years of Florida State Prison. Doesn't mean you go into prison, folks. It just means that's what you're facing as a maximum. All right. What if I pull out a gun and I tell you I'm going to shoot your sorry ass? That is now, or I point it at you, aggravated assault with a firearm. That is also a third-degree felony, punishable by up to 5 years of Florida State Prison. One exception, folks, and it's a huge exception. You're facing not one, not two, but 3, right? With my big mitts here, I'm going to damage you, right? 3 years of Florida State Prison minimum mandatory sentence. That means if you have a sorry lawyer and you plead to it because either he didn't work hard or your facts are terrible, then you're going to go to prison for 3 years because the statute requires it. If you take any plea or if you're found guilty, you're looking at a 3-year sentence. It's minimum mandatory sentence. So, before you think about pulling out a firearm to settle a dispute, you've heard people say it, you've heard people in the news say it, you've heard gun range owners say it, you've heard policemen say it, do not pull out a firearm in the state of Florida unless you're using it. All right? If you pull it out, you're not likely to get charged with a small charge of misdemeanor reckless display of a weapon. You're more likely to be charged with aggravated assault with a firearm with a 5-year minimum, a 5-year maximum sentence and a 3-year minimum sentence if you plead to it. Think about it, folks. Assault, I'm going to hurt you. Aggravated assault, I'm picking up Lady Justice here to smash your brains in. Aggravated assault with a firearm, serious stuff. 3-year minimum mandatory sentence. I'm attorney Roger P. Foley. Questions, comments, feel free to reply. Be happy to answer any questions. Thanks.